Okay, good morning. This is part 2 of my reviewer in Introduction to Philippine Criminal Justice System. So let us start. Question number 1. Philippines passed a law of nationwide curfew from 9 p.m. to 5 p.m. That's really 5 p.m. Because of the growing number of COVID-19 cases. Mr. B was caught by the police officers for violating the curfew hours. Mr. B argued that he is not aware that there is a curfew law and it is his constitutional right to travel. Is Mr. B criminally liable? Well, of course, the answer here is yes, because ignorance of the law excuses no one from compliance therewith. Okay, ignorantially is non-excusat. So, even if you do not know that there is a law prohibiting it, that is not an excuse. Ignorance of the law excuses no one from compliance therewith. Number 2, who among the following is not charged with private crime? Okay, so not charged with private crime. What is being asked here is not charged of private crime. Of course, the answer here is rape. Rape is not a private crime anymore. Adultery is private crime. Acts of lasciviousness is private crime. And seduction is also private crime. Before, rape is a private crime, but under the new law, it is not anymore private crime, it is a crime against person. Mr. K was charged with murder before the RTC. His bail application was granted upon showing that the evidence of guilt was not strong. However, he was convicted after trial of murder and sentenced to reclusion perpetua. May Mr. K be allowed to remain free on his original bail? Remember, he is already convicted, okay, after trial, and the penalty is reclusion perpetua. Okay, should you allow him to remain free on his original bail? The answer is no, because his conviction clearly shows that the evidence of guilt is strong. This time, the evidence of guilt is strong because there was already conviction. Number 4, during a bypass operation, Mr. M was arrested without a warrant. Bypass, of course, it is arrested. The person is arrested without warrant. The team leader, Police Inspector N, filed a complaint to the prosecutor's office. What will the prosecutor do? So after the person was arrested, okay, without a warrant, and of course the police will file a complaint to the prosecutor, the question is, what will the prosecutor do? What is now the action or the course of action of the prosecutor? Of course, the answer is to conduct inquest proceeding. Why conduct inquest proceeding? Because the person was arrested without a warrant. Okay, the person was arrested without a warrant. 5. Who among the following will undergo preliminary investigation? Okay. Remember, the question here is, when is preliminary investigation is required? What is the penalty? Okay, so that preliminary investigation is mandatory. So the answer here is of course letter C. Mr. Q charged with offense punishable by at least 4 years, 2 months, and 1 day. So remember, if you're talking about preliminary investigation, remember the formula, at least 4 years, 2 months, and 1 day. It is not 6 years. Okay, PIE, preliminary investigation is not 6 years. Okay, it is not 4 years, 2 months, and 1 day lang. Okay, it's not. There must be at least 4 years, 2 months, and 1 day. Because when you say at least 4 years, 2 months, and 1 day, when you say 4 years, 2 months, and 1 day, and above. Okay, and above. 6. After X, a rape suspect was apprised of his rights to silence and to counsel. He told the investigators that he was waiving his right to have his own counsel or to be provided with one. No? He made this waiver in the presence of a retired judge who was assigned to assist and explain to him the consequence of such waiver. So, of course, you make the waiver in the presence of a retired judge. Is the waiver valid? Is the waiver valid? Well, the answer here is no. Okay? Because it was stated that it was reduced into writing. 7. A group of criminals abducted an 18-year-old lady in the Mandaue City. They brought her in Lapu-lapu City and take turns of raping her. After 3 days, the lifeless body of the girl was found in Cebu City. Fortunately, the suspects were identified. Which court has jurisdiction? So remember, the abduction was conducted or made at Mandaue. The rape happened in Lapu-lapu, and the body was found in Cebu City. So which court has jurisdiction? Well, the answer is foregoing. Because remember, you can file the case in any place where essential ingredients occurred. If something happened in that area, then you can file the case there also. Okay? But of course, you cannot file that in Karkar City because nothing happened in Karkar. That was Karkar. 8. Metropolitan Trial Court convicted Mr. B and Miss D for concubinage. Pending appeal, they applied for bail, claiming they are entitled to it as a matter of right. They want to apply bail as a matter of right. Is their claim correct? Remember, they are charged with MTC. They were charged at MTC. Okay? Is bail a matter of right in MTC? The answer is yes. Bail is a matter of right in Metropolitan Trial Court before and after conviction. That's the general rule. Bail is a matter of right before and after conviction. 9. An information for murder was filed against X. After examining the case of records forwarded to him by the prosecution, the trial judge granted bail to X based on prosecution manifestation. It was not objected to grant of bail. Is the trial judge correct? Remember, the case filed here is murder, and murder is non-bailable. Okay? The only way that a person charged with murder can post bail is when the evidence of guilt is weak or it's not strong. But the judge is required here to conduct a hearing, a bail hearing, in order to determine if the guilt is strong or not. Okay, so is the judge correct by granting bail based on prosecution manifestation that it is not objected to the grant of bail? Of course, the answer is no. The trial judge should have held the hearing to ascertain or determine the quality of evidence of guilt that the prosecution had against X. Okay, they need to have a hearing in order to determine the evidence of guilt is strong or not. 10. The city prosecutor charged Mr. Ben with serious physical injuries for stabbing M. He was tried and convicted as charged. A few days later, Mr. T died due to severe infection of his stab wound. So, namatay. The prosecution filed another information against Mr. B for homicide. Okay, so first charge was only physical injury. But later on, the victim died because of that injury. Okay? And they want now to change the crime from physical injury to homicide. Is that allowed? Actually, the answer is yes. Remember the term, there is supervening event. Supervening event. If there is supervening event, you can change the crime, the charge, from physical injury to homicide. If there is supervening event. Then, when may an information be filed in court without preliminary investigation required in a particular case being first conducted? So, when does an information be filed in court without PI? Kailan ba hindi kailangan ng PI? Well, if there is an inquest. Okay? Following inquest in case of those two polarized without warrant. So, inquest is equivalent to PI. So, hindi na kailangan ng preliminary investigation if the prosecutor conducted the inquest. 12. Who among the following is not authorized by law to conduct preliminary investigation? So, who among the following is not allowed to conduct preliminary investigation? Well, under the law, it is the judge. The judge cannot conduct preliminary investigation because preliminary investigation is not a judicial function, it's an executive function. Okay? City prosecutor, yes, he can conduct preliminary investigation. Provincial prosecutor, yes, he can conduct preliminary investigation. Also, the regional state prosecutor, but not the judge. The judge cannot conduct PI. The question is not authorized to conduct PI. 13 to 15, John stabbed Peter during their fist fight, which caused the untimely demise of Peter. He was arrested following the hot pursuit operation. He was arrested, hot pursuit, conducted by elements of PNP. What crime can be charged against John? Well, the answer here is it's already stated. The answer is, of course, homicide. The answer is homicide because there's no showing of any qualifying aggravating circumstance of murder. There was no treachery, evident premeditation, abuse of superior strength. They were having a fist fight, nag-aaway sila. So that's only homicide. What will the prosecutor do with the case? What is the course of action of the prosecutor? Okay, the answer is, of course, is conduct inquest proceedings. Why inquest proceedings? Remember, he was arrested after a hot pursuit operation. He arrested without a warrant. So the prosecutor will conduct preliminary investigation. 15. Can John post bail? The answer is yes. Because the crime is bailable. Homicide is bailable. Murder is non-bailable. Okay? Homicide is bailable because it's only punishable by reclusion temporal. It's not reclusion perpetua. So, it's bailable. Mr. A deliberately shot Mr. B. Mr. A was charged with homicide, which is punishable by reclusion temporal. Temporal is 4 years to 1 day to 20 years. 4 years and 1 day to 20 years. Which court has exclusive original jurisdiction? If the crime is homicide and the penalty is reclusion temporal, 12 years and 1 day to 20 years, where will you file a case? Of course, you will file it in Regional Trial Court because it is above 6 years. Above 6 years, Regional Trial Court. 6 years and below, Municipal Trial Court. Okay? That's the rule. 17. A group of criminals abducted an 18-year-old lady in Mandaue. They brought her in Lapu-lapu, take turns of raping her. I think this is already done, no? His lifeless body was found in Cebu City and the suspect were identified. Which court has jurisdiction? Okay. Of course, it is the any of the foregoing. Because something happened in Mandaue, in Cebu, and in Lapu-lapu. Okay, I think that's it for this session. I will give another review as part 3. Thank you.